This series, created by Time for Advice, is dedicated to providing you instant answers to all of your visa questions.
Good afternoon. I'm talking about Schedule 3 of the migration regulations. Now, what is Schedule 3? Well, Schedule 3 under the regulations applies an extra set of criteria that you must satisfy when applying for certain visas. And Schedule 3 can apply generally when you're making a visa application onshore and you don't hold a substantive visa. So that is, you hold a bridging visa, or you're here unlawfully and you don't hold a visa at all. So how do you satisfy Schedule 3? Well, there's a number of parts to the Schedule 3 requirements. So firstly, circumstances must have arisen after you last entered Australia. So it must have occurred since you arrived. Those circumstances were beyond your control and caused you to stop holding a substantive visa. Now, beyond that, you must also show that there are compelling and compassionate reasons for the grant of the visa, and that your last substantive visa did not carry a no further stay condition. And it's really important to remember that all aspects of that test must be satisfied. It's not sufficient to just show that you had compelling and compassionate reasons. In the current environment with COVID, Schedule 3 has become somewhat easier to satisfy. For many, it arose after they last entered Australia. It was obviously beyond their control, and because of the fear and anxiety and just issues with travel, they in many cases have been unable to exit Australia to apply offshore and found themselves in a position of holding a bridging visa or being unlawful. So it has been very much easier to get a Schedule 3 requirements satisfied or waived during COVID. Prior to COVID, it was very difficult. What circumstances will stand in the way of getting schedule or satisfying Schedule 3? Well, if it's shown that you've had a failure to comply with any previous visa conditions, that will hinder the application of Schedule 3. If it can be implied that you're deliberately trying to manipulate your circumstances to remain in Australia, then that can severely impact the ability to satisfy Schedule 3. Now, what visas does it attach to? Well, in very broad terms, it attaches to most family visas. It also attaches to New Zealand family visas, 461s, etc. It attaches to onshore tourist visas. So you really do need to be aware of whether or not you're going to have to satisfy these extra criteria when making an application. Now, can it be waived? Well, actually, in certain circumstances, yes, it can be waived. Partner visas, for instance, the regulations allow for the minister to waive in circumstances where it shouldn't be applied for compelling and compassionate reasons. So your ability to have the requirements waived really does depend on the visa that you're applying for. Otherwise, you will have to satisfy the conditions and satisfy every part of the test. Again, these are the sorts of things that you should take advice on. Timeforadvice.com, outline your circumstances, get a lawyer to advise, and map out your pathway forward and get some advice on whether or not you're likely to satisfy the requirements, especially with such things as partner visas where you could spend nearly $8,000 in a filing fee. Now, should you have a visa refused due to a failure to satisfy Schedule 3 onshore, then of course that's a reviewable decision and you can take it to the Administrative Appeals Tribunal to be clarified further. Thank you.